A brief history of due process. The idea might sound modern, but it's actually one of the oldest principles in law, a promise that the government must follow fair procedures before taking away your life, liberty, or property. The roots go all the way back to 1215 with the Magna Carta in England. In it, King John agreed that no free man shall be imprisoned or stripped of his rights except by the lawful judgment of his peers or by the law of the land. That phrase, law of the land, became the foundation for what we now call due process. It meant even kings couldn't punish people without following established rules. When the United States was founded, the principle crossed the Atlantic. The Fifth Amendment, ratified in 1791, declared that no person shall be deprived of life, liberty, or property without due process of law. Almost a century later, after the Civil War, the 14th Amendment expanded the same protection to apply to the states. Together, they built the backbone of procedural fairness in America. Over time, courts interpreted due process in two main ways. Procedural due process means the government must use fair methods like notice, hearings, and impartial judges. Substantive due process goes further, protecting certain fundamental rights like privacy, family, and bodily autonomy, even if procedures are followed. From the Magna Carta to modern Supreme Court cases, due process has always stood for one simple idea: power must play by the rules, whether it's a criminal trial, a property dispute, or a government agency's decision. The promise of due process is that the law applies to everyone, including those who enforce it.